Good afternoon, everybody. It looks like we are all here. Um, so we can actually just jump right in and start. Um, so let's see. Good afternoon. This is the Labor Committee. We are hearing Bill 20-0543. And the committee members that are here are Councilman Bill Henry, Councilwoman Mary Pat Clark, Councilwoman Danielle McCray, and our colleague, Councilman Robert Stokes, is not here due to the passing of his brother. So let's send our condolences and think of him during this hard time. From the mayor's office, we have Matt Stegman and Nina Demolis. And I'm sorry, Councilman, the sponsor is here, Councilman Christopher Burnett. From the law department, I see that we have Victor Tavolo and Elena DiPietro. Oh, Hillary, really? We have everyone today. And from the city council office, we have, I'm sorry, I see Rebecca Sims and I think, well, I saw someone else. Oh, Dominic McAlley. So we have everyone here. We'll again begin with Bill 20-0543, COVID-19 Employee Retention Bill for the purpose of requiring certain successor business employers taking control over certain businesses from incumbent business employers to retain certain employees. Requiring that the incumbent business employer to provide the successor business employer with a list of certain employees, permitting a successor business employer from not retaining certain employees under certain circumstances. Also requiring that posting of notices when certain business undergo a change in control, prohibiting retaliation against employees for seeking assistance from or cooperating with the Wage Commission, empowering the Wage Commission to issue subpoenas and administrative oath, establishing certain procedures for the administration of complaints by the Wage Commission, and requiring certain reports, defining certain terms, and establishing certain penalties and providing for a special effective date. This resolution was introduced on June 15, 2020. The resolution was sponsored by Councilmember Chris Burnett, and we can hear from the sponsor now if he has any comments about this bill.
Thank you, Madam Chair, members of the committee, and city staff for an opportunity to revisit and have a host a work session before the Labor Committee this morning. So the Hotel Worker Retention Act, essentially, just as a reminder, it extends the protections of the Displaced Service Worker Protection Act that we passed in 2017. It extends it to hotel workers by requiring new owners or management companies who acquire a new property to make an offer of employment to the existing hotel workers when they acquire that new property. It doesn't prohibit them from bringing in or impact any transition in ownership or in any impediments to bringing in their own management teams. And it also doesn't require them to hire more workers than they need. It only requires that the new management make an offer to the existing hotel employees at the property before hiring new workers. And as you heard from the chair, it is enforced by the Wage Commission. There are also a package of amendments that the committee should have for this, and whenever you would like me to, Madam Chair, I'm happy to walk through them.
Yes, so let's go ahead and start with one, and then you can just go through each one of them. It's fine with me. You're still on mute, Councilman.
Yeah, sorry. Okay, so the First Amendment adds a sunset provision, basically ending this in December 31st, 2022, which is when we believe the both I guess the public health side of the pandemic may be nearing an end. Obviously, I'm using maybe and speculatively because we really don't know. But it does add an effective end date. Oh, you have them up. Perfect. For this, the Second Amendment, Amendment number 2, basically limits this to hotel employees only. That was from conversation both with folks who work in the industry and some of the feedback we got to try and narrow the focus here to some of the folks who are most affected by this. Amendment number 3 basically says that the subtitle, the provisions in the subtitle may be waived if there's a collective bargaining agreement negotiated between labor representatives and hotel management. And number 4, oh wait, sorry, for this one there's only 3. My apologies, the other one has 4. So those are the 3 that we've put forth so far, Madam Chair.
Perfect. Before we go to the different agencies, anyone from the committee have any questions about any of the amendments?
Yes, I do have a question. I apologize that I didn't go through and figure out all Amendment 2, but are you saying that this no longer would apply to, there's 3 categories of, there's commercial property employer, there's event center employer, and then there's hotel employer. Are you eliminating, is the sponsor amending out the first 2 categories?
Yes, Councilmember Clark. It narrows the categories to just hotel employees.
Okay, thank you. Yeah, I was going to support it with all of them.
I'm guessing no further questions from anyone else on the committee before we jump into the agency. All right, and I just realized that we have our interim solicitor, Dana Moore, on a call as well. And so we can just go ahead and start with the law department if you guys want to tell us where you stand. And
right, this is Vic Turbular from the City Law Department. We're going to be fine with the amendments to this bill that were just read. And as we said in the prior hearing, that we are prepared to approve the bill for form and legal sufficiency.
Perfect, thank you. Office of Civil Rights, is anyone on a call from that office? Nope. All right. Anything from the mayor's office?
No, nothing to add at this time. Thank you, Madam Chair.
Perfect. HR, Kimberly.
Hi, everyone. No, we didn't have anything. We didn't take a position on this one, and we defer to legal or to the law department.
Perfect. All right. That's it. It looks like we can go ahead and move on this bill. We have testimony from folks who want to actually testify. The first person we have is Richard McCracken, and you're actually elevated, so you can just chime right in if you're ready.
Thank you. I really don't have anything to say about Bill 543. I'm really here to discuss 544 when it comes up.
All right, we'll just go on to the next person then. Is Stacy Fisher on?
I believe you're perhaps calling
Sally Fisher, yes.
Yes. That's okay. I'm on as well, but similar to Mr. McCracken, I'm here for the next bill.
Perfect. What about Tracy Lango?
Sorry, I'm also on for the recall bill. We don't have any testimony on the retention bill.
All right, so we can go ahead and keep going. And I'm guessing it's the same thing for William Murray and Ray Moore. Nothing for this bill, all for the next.
And we have
Okay.
basically, it's a little confusing because we have Sally Dvorak Fisher and also Stacy Fisher. They're two different people, but they're both on for the recall bill.
Okay, perfect. All right. If we can go ahead and, since there's no public testimony, move to, hold on for one moment. Amy Rower, you have your hand up. Did you have anything to add to this bill?
I also am here for the recall bill.
Okay, that's fine. All right.
Madam Chair, this is Matt Stegman from the mayor's office.
I'm sorry, Matt, go ahead. I'm sorry.
I don't know if you called on them. I don't believe that they've submitted a formal report, but I did want to say both for this bill and for the next bill that's going to be considered, those were both referred to the sheriff's office. And I just, for the record, wanted to state we did have a conversation with the sheriff's office. Both bills give the Civil Rights and Wage Commission the authority to issue subpoenas. So the sheriff would be tasked with issuing those subpoenas, and the sheriff's office basically had said that they have they do not anticipate any issues complying with that and doing that within the existing resources, since serving subpoenas is something that they already do as the normal course of their business.
Perfect, thank you. And so we'll just move right into amendment. If committee members want to move them all as a package or individually.
I'd like to move all three amendments, please.
Second.
Perfect. Moved by Councilwoman Mary Pat Clark and seconded by Councilman Bill Henry. Councilwoman Shannon Sneed, I'm a yes. Vice Chair is absent. Councilwoman McCray. Councilwoman
Yes.
McCray. Councilwoman
Yes.
Clark.
Yes.
Perfect. And Councilman Bill Henry.
Yes.
Perfect. And now if we want to go ahead and move this whole entire bill, that will be great.
Madam Chair, I'd like to move the bill as amended, please.
All right. Can we get a second?
Second.
All right. All right. I'm a yes. Councilman Robert Stokes is absent. Councilwoman McCray.
Yes.
Councilwoman Clark.
Yes.
And Councilman Bill Henry.
Yes.
Perfect. This bill passes and it will move on to second reader on Monday's council meeting. All right, we can now move to the second bill, which is bill number 20-0544. It's COVID-19 laid off employees' right of recall. It's the purpose of requiring certain employers to recall certain employees who have been laid off after the imposition of the COVID-19 state of the emergency, specifying the procedure by which the recall would operate, prohibiting retaliation against employees for seeking assistance from or cooperating with the Wage Commission, empowering the Wage Commission to issue subpoenas and administer oath, establishing certain procedures for the administration of complaints by the Wage Commission, requiring certain reports, defining certain terms, and establishing certain penalties, and providing for a special effective date. This resolution was introduced on June 15, 2020. This resolution was sponsored by Councilman Chris Burnett. And Councilman, if you have any comments for this bill?
I do, and thank you, members of the committee, again for the opportunity to hear us out on this one. So this bill, if you recall, It is in response to large numbers of hospitality workers in Baltimore being laid off due to no fault of their own during the COVID-19 pandemic. Some of them have not been offered their former jobs, even as businesses have begun to reopen to even limited levels. Obviously, most are not operating at full capacity, but we do know that some have started their operations again. This bill would, there's some amendments, but it primarily would focus on hotel employees as well. But doesn't require employers to hire anyone back if they're not reopened, which is I think a key piece to this. It does not force the hand of any business to reopen. It just means that when they do, that those workers have an opportunity to come back. And it also, there's some amendments here that address this a little bit better, but than the original iteration. But it is essentially to try and protect workers during the pandemic, give them an opportunity to return to their jobs. We did add some clarifying language on the length of time, length of service with that employer that I think addresses some of the concerns that have been raised. And also allows, well, I'll walk through the amendments when you're ready. I don't want to talk through that just yet, but that's the overview of this. It is doesn't force anyone's hand, but it does give some priority to people who were already with the employer to have the opportunity to come back to the job that they lost during the pandemic.
Any comments or questions from any of the committee members? Nope. Okay, you can move right into amendments.
Okay. All right. So again, the committee should have the amendments already. And there we go, up on the screen. So there's a package of 4 amendments for this one. The first amendment, similar to the last bill, adds a sunset provision to the bill of December 31st, 2022. The second amendment adds more clarity around the length of time that the employee was with the employer in order to be eligible for this. So it adds a language that basically says if they've been with the employer for 90 days or more within the 12 months preceding the most recent separation for active service, or failure to be scheduled for customary seasonal work from that employer. And so it does add a little bit more clarification there. The third amendment, sorry, I'm going to work through multiple tabs here. Third amendment for this one. Go. Okay. It also allows the employer to make simultaneous conditional offers of employment to multiple laid off employees at a time, which we hope make this easier for employers to implement, so that they can move a little bit faster in their rehiring process when they reopen, and can make multiple offers. And the fourth amendment, similar to the last one, basically says that these can be waived in a collective bargaining agreement between labor and management. Thank you, Madam Chair.
Thank you. So we'll go ahead and jump right in and start with the law department for them to give feedback.
Hi, Madam Chair. This is Hillary Ruley from the Law Department. We stand by our report from the initial bill. We have never received these amendments, so we can't comment on their legality at all. But we, again, we've seen the recent letter by the Public Justice Center. We've re-reviewed our analysis and discussed it, and our underlying analysis of the bill doesn't change. But again, we've never seen these amendments, so we can't comment on those.
Okay, thank you. Is someone on now from the Office of Civil Rights? No. Okay. The mayor's office, Matt, do you want to comment on anything?
No, not at this time, Madam Chair. Just to say, like our colleagues in the law department, the mayor's office also hasn't had a chance to review the sponsor's amendments yet. And if possible, could I request that a copy be sent that we can send around? And yeah, I suspect that this may be true for most of the agencies that have been referred this bill, that they have not had a chance to review these amendments yet.
Sure, absolutely. And Department of Human Resources.
Hi, Madam Chair. So, yeah, we did not take a position, but we did have suggestions, and I believe that they were actually addressed by the amendments. But like Matt said, I haven't had a chance to look at them closely. Would it help to mention those real quick?
You can mention it, and we may need to maybe hold off on then taking a vote for this bill and allowing everyone to have sufficient time to review the amendments. Councilman, would you have a problem with that, just so they have enough time? Maybe we can come back.
Yeah, I mean, oh, sorry. I mean, not ideal. I apologize for that. That was an oversight. I know we sent it to the committee and committee staff, but it was an oversight to not get it to Matt Stegman's office on our part. So I'll follow your lead, Madam Chair, on that.
Okay.
So I'll just add to that. We are primarily deferring to legal and wage, but the issue was that for the status of a permanent employee, it was more days. So I just will have to check if the language, because for Baltimore City, it's not 90 days, it's 6 months. So that part may be covered by the change that was made. And then the other, I believe, is covered by the multiple offers. But I wasn't sure if you shortened the length of time. Because we had asked that it be the length of time for accepting an offer be shortened for the reasons that you may have put forward, allowing the multiple offers. So just wanted to put that on the record.
And Madam Chair, I just wanted to add, I did just get a copy of the amendments from the bill sponsor, and I'm going to get those around to all of our agency folks as soon as possible.
That's it for HR. Thank you.
Thank you. I appreciate it. Thank you, Matt. Since you're going to send them around to everyone, would the law department be willing to take a quick look at the amendments for this bill, and maybe we can still vote it out today? Or is the law department, are you guys going to need a day or two to look over it to get back to us?
I mean, I don't know what they, it's hard to understand what they entail. This is definitely, a complicated bill, and our, report was fairly long, so I can't, I don't know exactly how long I would need to review them, but I would think you probably wouldn't want to rely on something I did, just, on the spur of the moment. I think we need time to review.
Okay, so we'll probably we won't vote it out today, then we'll have to come back, but we can still get through the panel list. So if the people who
Madam Chair, if I may,
yes.
would it be possible to, I mean, I understand the concerns about some of the more substantive amendments, but for example, the sunset provision, I think, is pretty straightforward. So I don't know if you would be, if you want to move them as a package, that's great. And I don't have any opposition, but just would flag that, that one in particular, is not particularly substantive change to the bill. But I'll defer to you on that.
Yeah, but I still, if someone hasn't had the chance to look over it, it would be the same thing for us, that I would want us to have the time to review it, so we can ask our questions. I just rather be on the safe side than to rush it through. That would just be my stance, is just as a person.
Madam Chair.
Yes, Councilman.
Thank you. It occurs to me that there's also the option.
So Councilman, we're getting every other word. We're
Law
not.
Department from now until Monday evening to let me.
Madam Chair, I didn't hear anything you said. I don't know if anyone else is having a problem.
Me either, but I think he was going on the line that we can hopefully, maybe if they can review it, and maybe if we can have something by Monday. I'm not sure where he was going.
Can you hear me now?
Yes, we can hear you now.
Now? With the data stream, what I was going.
Sorry, Councilman, we're not hearing anything that you are saying.
Until
we're not hearing any.
Next Monday evening.
Councilman, we're not hearing anything that you are saying. Maybe if you could put it in the chat and type it, that could be a little better and we can read it. That can work.
Madam Chair.
May I?
Madam Chair, I've got Councilman Henry on the phone now. If you don't mind, I'll just have. Councilman Henry on the phone. Councilman, make sure you mute yourself on WebEx, by the way.
Yeah. Yeah. Thank you. Okay. So I have muted myself. No one needs to mute me again. But I need to turn my speakers off.
Everybody can hear you now. Yourself too.
Okay. So what I was trying to say was, if we pass the amendments today and the law department discovers something that needs to be fixed before Monday at 5, then we can either make that change as a floor amendment at the council meeting, or if it's something incredibly complex, we can hold the bill over to the following meeting, and we won't have lost any more time than we would by not voting today. But that allows us to stay on the track of bringing it out for second reader next Monday if there aren't problems that can't be resolved in the next couple of days.
Madam Chair.
Hold on for one moment, Councilwoman. I think you're saying go through with everything, but your suggestion that is go through with everything, but if there's any changes that the law department has, we can do, you're recommending to just do floor amendments. Is that correct?
That's correct.
Okay.
And Madam Chair, I'm supportive of that, and absolutely willing to commit to that. If there's, real concerns from the law department about anything being proposed, I wouldn't want to move this forward anyway, but we are very limited on the number of meetings left in the term. I think that's a recommendation I would be absolutely supportive of, if the committee is as well.
Okay.
Madam
Councilwoman, yes.
No, I just wanted to support Councilman Henry's recommendation. I've been through these amendments, and a couple of them are just very, they're just about the termination date. They're and the one that is has the most words to it. Really, basically, is clarification of a terminology. And I, for one, as a member of this committee, I've been through this bill a couple different times in all of its reports, and I feel comfortable with these amendments. So I would like us to ask the law department. It is only Thursday. It feels like Friday, but it's really Thursday today. Perhaps by the end of tomorrow, they could have taken a look at the amendments that are not just really termination dates and things like that. I would like to, there's a certain urgency about what this is about. And I know we may not all be in the same side of it, but as a person who thinks it's really important, I would like to see it move as quickly as possible, please, with all due speed. Thank you.
So let's hear from, well, thank you, Councilwoman. Let's go ahead and move to the panelists now. And so whoever's on the phone and whoever is on the, who's on a call with us, we can get right in. So we'll start with Richard again.
Thank you. This is not a complicated bill. It's actually very simple. It's very straightforward. It's very fair. It has been seen so by major jurisdictions. So far, the only jurisdictions to have passed this are in California, but California is a big state. The city of Los Angeles passed this. The county of Los Angeles passed this. Several municipalities within the county of Los Angeles have passed this. The city of Oakland passed this. The California legislature at the end of August passed this. All it provides, and again, it's very straightforward, is that as business comes back, workers come back. It's hard to see why anyone could object to that idea, because we certainly want our businesses to come back in the industries that have been so heavily affected by the COVID crisis. And those are the ones that are named in this ordinance: the hospitality industry, hotels, event centers. As you know, event centers are shut down, and that has to do with both sports and also live entertainment. And then building service, because the many or most office buildings are either shut or on very limited service. So all the people who worked in those buildings are also out of work. So the question is, why wouldn't a company that was operating one of these businesses and laid people off only because of the COVID crisis, not because of anything that they did, but just because of the COVID crisis, why wouldn't it bring back the same people? That's all this law does. And the other things about it are straightforward. It provides for enforcement by the Wage Commission. It provides against retaliation. So if someone exercises a right under this law, they're protected against retaliation. A standard provision in virtually all laws that protect workers and whistleblowers, I should say, as well. So again, we have a very straightforward law. It's been passed by the jurisdictions I named. Even though the California Employers Council issued the opinion that is attached to the Department of Law's opinion, claiming that there was a contracts clause problem with this that made it unconstitutional, that group and no other has taken any action against any of the laws that have been passed. Unfortunately, the law department has uncritically accepted the conclusion of this California employers group, even though that group has not acted upon their opinion. They haven't acted upon it because there's nothing to it. The easiest way to demonstrate the lack of any substance to the contention that this would violate the contracts clause is by reference to the bill that you just passed out, which is our worker retention law. You already have one on the books. the Displaced Service Workers Protection Ordinance. It has not been attacked. And there are hundreds of these ordinances and policies throughout the United States. They were attacked for a while. They were attacked in Washington, D.C., and in California, and in Rhode Island. But the last of those attacks subsided several years ago because they all failed. And the contracts clause was one of the many reasons, it was said, why the worker retention laws were unconstitutional or preempted by federal law. And those arguments were rejected, plainly rejected. And first of all, by the District of Columbia Court of Appeals, in an opinion in the 90s. And the court made the very obvious observation that seems to have escaped the critics of this law, that no one is being required to alter any contracts, let alone break any contracts, because there's no contract yet. People haven't been hired yet. What the Court of Appeals said was that there's no issue at all, even to begin with, under the contracts clause in a worker retention law, because no one has been hired yet. There's no employment contract to impair. That's what the court held, and that's what all the other courts have held too. That's even more true about this law, because in the worker retention law, there are people who are already in place there and employed. In this, we're talking about people who are going to be hired in the future. And so if it's not a violation of the contracts clause to say that a new employer who takes over, say, a hotel, has to retain the employees who are there, in other words, has to hire those people, if that's not a violation of the contracts clause, how could it possibly be one to say that people you're going to hire in the future? Right now you don't have employees because you're either shut down or you're very much reduced in your service. How could it be a violation to say that people you're going to hire in the future who you have no contractual relationship with now are in a different posture than people who are actually employed and have a contract for employment now? There's no logic to it at all. And unfortunately, what the California Employers Group did was to pick up an old, obscure Fourth Circuit case. That's their only authority. It's 40 years old. Involves insurance industry. It involves an entirely different set of circumstances. The court there limited its opinion. Nobody seems to have actually read that case and told you what it actually held. They didn't invalidate the law even. There was a law about the termination of insurance agents' contracts by the insurance companies that had them write policies. The court didn't even invalidate that law. All it did was to invalidate a retroactive judicial creation of a private right of action for insurance agents who were terminated. And there's something that I know that we're not talking about an appellate argument here, and it may sound like that's what I'm doing. I'm going to read from you what the court said. The court said very clearly that we hold that retroactive application of the private enforcement provision of that law impermissibly impairs the obligations of the agency contract. All they were talking about was a private right of action and retroactive creation of that private right of action. And the court was very careful to confine its opinion at the beginning of its analysis by telling the reader, in making this analysis, it's important to keep in mind that the legislation under challenge is not the comprehensive act about the regulation of insurance, and not even the provision about the termination of insurance agents, but only the private enforcement provision for the violation of that section. That's all that case was about. And the court went on also to find that this law was only for the private benefit of the insurance agents. It had no public purpose. So we're talking about as I say, an old, but not only old, but irrelevant case. And that's the only authority that the California Employment lawyers who advocated the same position before the city of Los Angeles and failed, have given to the Department of Law, which has accepted them. In the contracts clause, it's necessary to do a 3-step analysis. The law department's report does not do that. It simply treats this case as standing for the proposition that whenever you do anything that affects a private contract, that's a violation of the contracts clause. Well, that's so far from the law that it's surprising that the law department is still standing by this opinion. Because under the Supreme Court's decisions, you have a 3-part analysis. And the first part is whether the law would impair any contract. That's where you start. As the courts have held with regard to worker retention, those laws do not impair any existing contract because people haven't been hired yet. That's the same as this law. This analysis doesn't even get to first base. But the second element is whether the law is addressed to the remedying of some social and economic harm. Is there a social and economic harm that this law is addressed to? It should be pretty plain that it is. We're dealing with the worst crisis in these industries that has ever been experienced. The American Hotel and Lodging Association says that they assess that the effect of COVID is 9 times the effect of 9/11, when the whole industry took a deep dive as a result of the cessation temporarily, as it turned out, of air travel primarily. So this is the biggest crisis this industry has ever faced, even in wartime. This is the biggest crisis ever. So with regard to the second element of contracts clause analysis, is there a social and economic harm to be remedied here? The answer is yes. Thousands of people have been put out of their jobs, not because of their own fault, but because of the virus. And this law remedies that by bringing them back to work. And that leads to the third part of contracts clause analysis, which is the balance between the impairment of the contract, if there is one, as there isn't here, but assume there was one. That's one part of the balance. The other part of the balance is whether the remedy adopted by the government is well suited, is tailored to the problem. Well, this is tailored exactly to the problem. People were laid off because of COVID. They're brought back. Same people. This law is an obvious winner against the contracts clause problem. There's no serious argument. And of course, even though this same argument was made to the city of Los Angeles, they paid no attention to it. And then it turned out to be a bluff. The employer said, this is a violation of the contracts clause. City passes the law, it's in effect. Is there a lawsuit? No lawsuit. Same with the county. So unfortunately, and I know I've spoken probably too long, but I do want to point out one other thing. And that is that this approach to the contracts clause would wipe out a lot of other laws. Because if you say that anytime you tell an employer who the employer has to hire, that means your displaced workers law and the one you just passed out, they're invalid. It also means your landlord-tenant laws are invalid, because landlord-tenant's also a contract. You have a law on the books now, a very important one, that gives a tenant a first right of refusal if the landlord is going to sell their unit. They get a right to buy it. That's the first right of refusal. That limits who the employer deals with. That's a contract clause violation if the law department is right. Fortunately, they're totally wrong. And you don't have to worry about all the rest of your laws that will go under as a result of this type of analysis. Thank you for your patience.
Thank you. Thank you. We'll next have Stacy Fisher.
Hi there, can you hear me? All right. Hi, my name is Sally Dworak Fisher, and I am an attorney at the Public Justice Center here in Maryland, where I work on the Workplace Justice Project, primarily representing low-wage workers in employment matters. And I just wanted to discuss some of the constitutional concerns that have been raised about the bill, and specifically allay concerns that this bill would violate the Contracts Clause of the U.S. Constitution. I'm going to try not to repeat what Mr. McCracken has said. I do want to direct you not only to our written testimony, but to the letter that you have from Mr. McCracken's firm that makes many of these same points. So my testimony today, I'll just briefly address three main points. First, what is the analysis? How can you tell whether a bill is going to violate the contracts clause? Second, what is freedom of contract theory and how does that apply to at-will employment? And then third, I just want to touch on why the cases that are relied on in the law department memo actually don't apply in this context. So jumping right in with the analysis, as Mr. Kraken just described, it's basically a 3 or 4 part test. And the first question is there interference with an existing contract? In other words, is this bill going to affect contracts that are in existence? If it doesn't, the contracts clause just doesn't even apply. It's not even implicated. If it does, then you get to the questions of, well, is it a substantial impairment, and is there a rational basis? Is there some legitimate justification for this law or for the bill? And here, as Mr. McCracken mentioned, the contracts clause isn't even implicated in this because at step 1, there is no existing contract to interfere with. This bill simply requires an offer of an employment. It's not dealing with a current employment relationship. It's dealing with a hypothetical future employment relationship with former employees. Now, perhaps sometime in the past when they were employees, there was a contractual relationship. But at this point, they've been laid off and you're just talking about an offer of employment. So we don't even get to step 1 in the contracts clause analysis because there is no contractual relationship to be interfered with. I wanted to point your attention to the similar bill that was analyzed by the DC Court of Appeals. That required new employers to retain employees on the books for at least 90 days and had just cause termination provisions in it. But even there, the DC Circuit Court, the Court of Appeals for the DC area, recognized when it was looking at that bill, it said there is no existing contractual relationship to be impaired, to say nothing of substantially so. So again, here, we just don't even have an existing contract to have any sort of federal violation of the contracts clause. With that, we noted in our testimony, it's worth remembering that the courts have rarely found that any legislation violates the contracts clause, and they give great deference to the legislature to pass economic regulation that's for the health and safety of their residents, and that's what this bill does here. In the years since the 1930s, there's only been one law affecting private contracts that's held to violate the contracts clause. And the legislature is given great deference in terms of knowing and understanding what people need. So what about freedom of contract? The law department's report talks about this freedom of contract, which I confess when I first heard it, I thought it sounded great. Freedom of contract, though, it's a due process theory that was recognized by the Supreme Court a long time ago, before the Great Depression. It reflects like a real commitment to laissez-faire economy. Let the economy do its job, and individuals have the freedom to sell their labor and enter into contracts to purchase their labor. Again, though, it was the basis of declaring unconstitutional many laws and much of the New Deal legislation, including minimum wage laws. And, sometimes we refer to this in legalese as the Lochner error. But the Lochner error is dead, and freedom of contract has met its demise after the Great Depression. Justice O'Connor, writing for the Supreme Court in the 90s, explained that 14 years after this freedom of contract was recognized, it met its downfall with the recognition of a right to a minimum wage in a 1937 case. So freedom of contract is a theory that's been sort of not a theory that's been legitimated by the courts since basically the 1930s. So the approach to reviving the freedom of contract has just been rejected again and again. And the Supreme Court said in 1992, look, if you read every workplace regulation into private contractual arrangements of the employers and employees, you'd expand the definition of contract so far that the constitutional provision would lose its anchoring purpose. In fact, the clause would protect against any change in legislation. And that leads me to this discussion of at-will employment relationships. So just a quick note about at-will employment. At-will employment is the default rule in Maryland and across the country. And it generally allows for termination of an employee for like any reason at all, like the boss didn't like the color of the socks. But at-will employment is not and has never been unlimited. You cannot fire people for unlawful reasons. And many, many laws that are constitutional have modified the at-will employment relationships. So it's the general rule, but it's not sacrosanct. And it's not the case that it can never be modified. Here, the employees were at-will employees at the time they were laid off. The bill is not punishing or limiting any employer's past decision to terminate them. Once it is terminated, there is no employment relationship. They are former employees, and the bill would simply require an offer of employment. If and when they are rehired, they will be at-will employees subject to any sort of worker protective laws that may apply. So the at-will employment relationship really is not adversely affected here in any way that violates the Constitution. And just briefly, in terms of the case law, I know Mr. McCracken already mentioned the Garris case from 1980 that was relied on by the memo from the California people. Again, even in that Garris case, the court concluded that there was no substantial existing contract obligations that were impaired. And the other case that's sort of mentioned in the law department's report is Bailey's Campground versus Mills. But, Bailey's Campground wasn't even a contracts clause case. Maine had been attempting to close its borders during COVID. And that was analyzed under constitutional right to travel, which means it was subject to increased scrutiny. And yet, even that, subjecting it to increased scrutiny, the court denied the injunction request. So Bailey's Campground didn't even hold that the order banning travel was unconstitutional. So those cases really don't provide a substantial justification to conclude that this bill would be unconstitutional. I think I'll end there for any questions with the constitutional issues, and if there are none, I'll conclude there. Thank you.
Thanks, Sally. Are there any questions for Richard or Sally from the committee before we move forward? No? Okay, thank you. We'll move right along. Tracy, if you want to go ahead.
There we go. Am I unmuted? Okay. Thank you so much for your time and for inviting us to give testimony today. My name is Tracy Lingo. I'm the staff director of Unite Here Local 7. We represent over 3,000 food service, hotel, stadium, event center, and casino workers throughout Maryland, with the majority of our members living here in Baltimore City. As you know, hospitality workers in Baltimore are facing an unprecedented jobs crisis due to the COVID pandemic. In May, the worst month of this pandemic so far, for job loss, leisure and hospitality employment was down by 50% over the same point last year. For comparison, overall job loss in Baltimore was down 12%. So that really shows you how much this crisis has affected hospitality more so than the general economy. I really want to point your attention to a report we put out this week entitled "Baltimore Hospitality Workers Face a Job Crisis and Black Women Are the Most Impacted." You'll see it in your packet of written testimony. What I wanted to point out is we can really clearly see in Baltimore how the racial justice implications of this crisis are playing out as we're seeing across the country. At the Hilton Baltimore, the site of the city's largest hotel layoff, 69% of the workers laid off are Black women, are Black, and 58% are women. At the Baltimore Marriott waterfront, our estimates show that Black women are the largest single group of laid off workers, with 48% of workers being Black, 20% Latinx, and 14% Asian. 52% of all laid off workers at the Marriott were women. And I'm using those two cases because we don't have reliable data on race and ethnicity for all of the hotels, but we do there. But I would suspect that they're a pretty reasonable test case of what's going on across the city. So hospitality is the city's third largest employer. Baltimore has invested heavily in the hospitality industry, not only with tax breaks and pilots, but through workforce development and training. MOED has invested time and money in hospitality academies, recruitment, job readiness training, and job fairs to encourage city residents to choose careers in the hospitality industry. And I'm saying this to point out that our investment in the hospitality industry has not just been for the sole purpose of tax revenue. It's really the city's interest in the hospitality industry has been to ensure that city residents can access jobs that allow them to stand on their own 2 feet and support their families and their communities with dignity. And in fact, you're going to hear from the testimony of the workers who speak after me how much that's been the case. Our members really have been able to be the person that time and again, as we prepared for this bill, I've heard stories from our members about how they are the person their families, their extended family, and their community turns to when someone can't come up with money for school clothes or field trip money or is short on the rent. And I really think we need to think about the city's vested interest in this industry in terms of how that economic stability affects all of our neighborhoods. So in the past mass layoffs, we've seen how crucial it is for workers to have a clear and established path to get back to their former jobs. And because we've seen that workers who ties were completely severed from their previous employer often faced much longer times on unemployment than workers who were recalled or had some continued connection to their employer. While hospitality workers who are members of our union have some protection against permanent layoffs in their collective bargaining agreements, it seems likely that the layoffs may last longer than these current recall agreements would cover. We're all learning as this pandemic goes on, but we're anticipating that it's very likely we're not going to see a return to large-scale banquet or convention events probably until after we see a vaccine. A lot of the union contracts have 9 months or a year for recall rights. But the other thing that I also wanted to point out is we need to remember that the large proportion of the hospitality industry is non-union and does not have any recall rights now legally. And so pretty much as soon as the pandemic started, we started to hear from non-union hospitality workers who were immediately terminated from their jobs and who were told they could reapply at a later date, but that there was no guarantee that they would be rehired. And obviously for folks who have put a lot of time and train into becoming professionals in their field, it's a very difficult situation. We've heard from lots of people who are in their 40s or 50s and who are saying, I've been a banquet server since I was 15, since I was 19. What am I going to do that's going to give me the same level of economic security at this point in my life to try to change careers? So both the COVID-19 laid off employees' right to recall and the retention bill that we just passed out are common sense measures that we urgently need to create stability in the hospitality workforce. Without this action, thousands of Baltimore residents and workers risk dire economic uncertainty. The city has a vested interest in ensuring that the hospitality workers we have invested in have a clear path to be rehired in their former careers. Hospitality workers have stepped up to be ambassadors for our city and have worked hard for the success of our economy, and now is the time for all of us to stand with them. So I'm going to end there and see if anyone has questions before we move to the worker testimony.
Thank you, Tracy. Any questions from it doesn't look like the members have any questions. So we're going to move right along. Stacy Y is up next.
She seems to be having trouble with her audio. I'm going to go check and try to problem solve.
Okay, well, next up, we'll just skip right to William. William, are you still on the line? Whoa, okay, William's not there. We're going to move right along. What about Ray Moore? Nothing. Okay, we'll come back. We're going to try the folks on the phone. You'll hear 3 beeps.
This is William. Can you hear me?
William, yes, go ahead.
Oh, I had to unmute myself. Good afternoon, council members. Thank you for taking the time to hear our testimony today. My name is William Murray. I have been a banquet server at the Baltimore Marriott Waterfront since it opened in 2001. Baltimore has invested millions of dollars in building the hospitality industry as a way to create jobs and improve our city. As professionals dedicated to being the best ambassadors to our city that we can be, we have put a lot of time and training into learning how to provide world-class service. I've been working for Marriott for almost 20 years now. We've had all kind of high-profile events. We have the National Council of Bishops every year. We have most of the opposing teams of the Ravens. We've had film crews to stay at the hotel. Even Oprah Winfrey did a show from Marriott back in the early 2000s. For me, being a banquet server has allowed me to be financially secure. I was able to buy a home in West Baltimore. I have 2 daughters. I have grandchildren. I take care of my niece. So I have a lot of family members that depend on me. Both my parents are in their late 80s. I'm my mother's only son. So, I like to be able to, to do what's financially necessary for me. The COVID-19 crisis has hit our industry very hard. I've been laid off since March. We don't really know when the hotel is going to be open for high-scale events as it once was. I believe that we should be able to have some certainty when all this is over, we can return to our jobs. We need you to act to make sure that all hospitality workers in Baltimore have the right to return to the jobs that we have built our lives around and that our communities depend on. Thank you for your time and support.
Thank you, William, and just thank you for all that you do for your friends and family that are here. Appreciate you. Is Stacy available now?
Yes, if you just, I'll put her at my desk. Stacy, come on in and sit at my desk.
Ray. Mm-hmm.
Okay, where I go? Go ahead and sit down right
Hi,
away.
Stacy. We're just waiting. You can go right ahead.
Can you hear me?
Yep, we can hear you.
Hello, how y'all doing, Baltimore City Council? My name is Stacy Y. I'm a housekeeper at Hilton Baltimore. I've worked there for 11 years, starting in 2009. Our hotel shut down in March due to the pandemic. Since then, my coworkers and I haven't been at work. When I began working at the hotel in 2009, my 2 kids were still young. The job allowed me to pay my bills and raise my kids. Now they are grown and living on their own, and I have a 9-year-old granddaughter that I also support now. Not only did the job help us financially, our hard work and loyalty benefited the company for many years. Now they should have the consideration to respect our rights to return. We should have the right to be recalled to our jobs when the hotel reopens. It's not our fault that we lost our jobs. We should not have to worry about whether we will be called back or not when we already worrying about our bills, our health, our family, and our community. To fire us to fire us while we are going through the traumatic experience of the pandemic would be cruel. Not only, I'm sorry, I apologize.
It's okay. Go ahead. We're patient.
Not only did I think I'm getting my words mixed up.
Stacey, you just be yourself. It's okay. So you can talk straight from your heart.
Okay, basically, all I'm saying is I've been out of work. Me, as well as my coworkers, has been out of work for almost 8 months now. We want our jobs back. We want to go back to work. We are loyal, dedicated workers. We should not have to worry about whether we're going to lose our jobs over a pandemic that we had nothing to do with. We just want our recall rights. We want our job. A lot of us has been there for years since that hotel has opened. And it would be cruel to not to be able to go back to a job that all of us love and wants to be at. So I'm asking you, as a member of the council, I urge you to pass this bill to give us the recall rights because we are loyal, dedicated employees. We love our job and we want to go back.
Thank you, Tracy, for speaking up. And I'll tell you that my husband as well is a employee. He works for a hotel and they've been shut down the whole entire time. So my family, and I keep saying over and over again, I don't know anyone who hasn't been impacted by COVID-19. So thank you again for your testimony.
Thank you.
Is Ray Moore available?
I'm up here, Councilwoman, Chairman.
Okay, go ahead.
Thank you, baby. Take your time.
I got a little.
Good afternoon, Councilwoman Sherman, the council, and all that's here today. My name is Ray Moore. I have worked at the High Regency Baltimore since April '97. Before the pandemic, I was doing very well at the Hyatt, but since the pandemic started in March, I have only been called to work one day during the summer. I live in East Baltimore. I grew up in the Flag House Courts projects, which is now Alomar Square. I went to culinary school to prepare for a job in the hospitality industry. I attended Southeast Culinary Academy in Kissimmee, Florida, and completed an apprentice program at Orlando Vocat. My first culinary job was at Hilton and Walt Disney World, but I have worked in many other hospitalities with Disney itself. Later, I moved myself and my family back to Baltimore. I got hired as a night cook at the Hyatt and then became a breakfast cook. They saw I was a hard worker and dependable. Because of my hard work, I was able to transfer from cook to banquet server, a better paying position. I've been working as a coffee break server in a banquet department for the last 18 years. During that time, I won the Hotel Motel Association Food and Beverage Employee of the Year. My job was supporting myself. I have 6 kids, but right now my youngest son is 22 and attending Delaware University. My job also allowed me to support a youth football team, Councilwoman Shannon Tweed, in the Bocheck community. Okay, I've coached youth football there for 15 years. Over those years, I have spent many $1,000s of my personal money to provide football uniforms, equipment, and allow the kids to play free without any fees. I'm 55 years old. After 23 years of hard work, I was so close to the finish line of my retirement. Now it feels like it's all being taken away. This crisis has been devastating to me. My life has not been the same. I've been very stressed. The thought of having to start over at my age and find a new job is very tough. We should have the right to return to our jobs when business returns. we are hoping that you make the right decision to pass this law to protect our recall right, so that we can get back to our financial lives. So I thank y'all for taking the time to listen to me, and I'm more than sure the council of Baltimore City are going to take care of the little people. Thank you.
Thank you, Mr. Moore. I appreciate you. Thank you for sharing, and I'll see you in East Baltimore.
Thank you, ma'am.
Okay, we're going to go to the attendees, and so you'll hear a number of beeps, and you can go right in and start speaking. So this is for anyone who's called in over the phone. So you'll hear it and we'll go right to you. And if it's still people out there, you can also use the raise hand function so we can make sure that we get you as well. So let's begin with Donald Fry. You're the first one.
Thank you, Madam Chair, members of the committee. I'm Don Fry, President and CEO of the Greater Baltimore Committee, and I'd like to make some comments and suggestions with respect to Council Bill 20-0544. I'm an attorney as well, but I promise you I'm not going to talk about the contracts clause or constitutionality of this legislation. That's for others to have debated previously. One of the areas I do have some suggestions and concerns about deals with the sunset date of December 31st, 2022. I have this concern also with respect to the previous bill that you passed, but unfortunately did not have an opportunity to make public comments on that bill. The original bill had no policy or substantive connection at all to the pandemic or the state of emergency that we're currently under. While this bill does create a sunset date, the date is really an arbitrary date. It still has no direct correlation to the pandemic. Our recommendation is in our written testimony that we've submitted to you, would that the bill would remain into effect for 30 days until after the governor's state of emergency ended, or December 31st, 2022, whichever occurs first. So that's I think that could have applied and should have applied to both those bills. I think it would have been a better connection, a better nexus directly to the actual pandemic and what you're trying to address right now. Some of the other amendments that have been proposed, we have some comments to. First of all, we don't think there's enough clarity with respect to some of the types of positions that are under janitorial or maintenance. In our written testimony, we have included some definitions for both of those that we think that could be considered. Most of the focus of this bill, of course, is on offers of employment, and there should be some exemptions or exceptions to requiring an employer to make an offer of employment. For example, if an employee has signed a severance agreement and they received consideration or compensation under that agreement, they should not be considered eligible as a laid-off employee, since that has already been provided for through their separation from their employment. Other circumstances that might be no longer appropriate for a laid-off employee to return to work from their employer. Some examples would be if they had abused or otherwise misrepresented eligibility under unemployment benefits with their employer, or if they had been convicted of a felony during the period of time where they had been laid off. I don't think that it would be appropriate to extend those protections onto employees under those circumstances. Another portion of the bill provides that a laid-off employee only has to work 2 hours a week, 2 hours of work within Baltimore City. That certainly does not suggest of a full-time employee at all. I certainly think that this should apply to full-time employees, and that should be changed to 38 hours a week. There is a assumption that all terminations after March 5th are non-disciplinary, although I would imagine that many of those were non-disciplinary because of the COVID crisis. To make that a rebuttable presumption, I think goes a step too far and is not appropriate in this bill. Some of the other concerns that we have dealing with the legislation deals with actually the filing of the complaint. The legislation provides that a complaint can be filed within 1 year from the date of the alleged violation. But if you read the bill on page 5, it virtually allows virtually anyone to make that complaint. There's not a requirement that there actually be a direct correlation of the person who makes the complaint to the employment situation that you're asking to have the complaint filed for. Also, the penalties that are in this bill, as well as in the previous bill that you passed, I think are unreasonable and unconscionable. Again, you have a period of a year to file a complaint. The penalty or assessments are at $250 a day for the first offense, and each day counts as a separate offense. If you take that for a period of a full year, that could add up to as much as $90,000. And I think that that is excessive. I think this should be reduced, or there should be a maximum cap that's placed on the penalties. And finally, for offering in a position of employment, bill allows for the employee 5-day business days to accept or decline. I think it would be more appropriate to reduce that to a 2 or 3 day business day period for acceptance, since we're talking about getting people back to work as soon as possible. Madam Chair, members of the committee, thank you very much for the opportunity. Those are our comments. Again, we have submitted written testimony on both this bill as well as the previous bill, which unfortunately there was no opportunity for public comment until you've already passed that matter. So thank you very much.
Thank you. We'll next go to, thank you, Don. We'll go to our next panelist. Frank Boston, you are up.
Boston. Mr. Boston.
All right, this is Rob with the City of Gaithersburg.
Yes.
So, hello.
Hi, Frank, you're live.
Can you hear me?
We absolutely can hear you.
Yeah. Good afternoon, Madam Chair and members of the committee. This is Frank Boston, and I'm here on behalf of the Maryland Hotel and Lodging Association. I'm an attorney, and first of all, I wholeheartedly support the analysis of the law department. I think it is on point. I think the analysis given by the other attorneys who are saying that it does not violate the contracts clause, I think the argument is flawed, and you're only looking at it from the eyes of injury to the actual employee. The contracts clause works both ways. There's two parties to a contract. And if you're looking at it through the eyes of the employer for the purposes of legalities is considered a corporate individual, then there is substantial harm. But let's think about the practical fact of the bill, the implementation of the bill. As you know, Madam Chair, you have relatives who work in the hotel industry. We wish we could hire everybody back. God, we wish we had that problem. We wish we were faced with a situation where we were recalling people. Here in Baltimore City's hotels are shut down. Not only are they shut down, the very few that are open are working off of minimum staff. You have supervisors, you have general managers working the front desk. They're trying to fill as many slots, as many positions as possible. So when you pass legislation, you have to think of the practical effect of everyone involved. We have hotels that if you look at some of these bills like this, forcing people to recall people, they just financially can't do it, so they're going to remain closed, and then we're going to have a ghost town downtown. Then the economy falls apart. Then you don't have conventions coming because there's no place to put people. Yes, we want light at the end of the tunnel. Yes, we recognize it's a pandemic, but it is impossible. It is impossible to comply with some of the structures of this bill. We've had conversations on the 90-day retention legislation, if there's a change of ownership. Well, no, although we have concerns, we aren't opposing that because we get it. We get the political, we get the policy considerations there. But this bill, as you move it forward, is for our industry, it's not workable. That said, one of the problems that are most problematic for us would be on On page 4 is lines 29 through 30. Sub Roman numeral 2, where it says could become qualified if provided with the same training that would be provided to a new hire worker position. We would like to see that portion of the bill stricken, if possible. I mean, that would leave, Roman numeral 1 basically saying, if the laid off his employee, he must be offered, be held. It leaves Roman numeral 1, which says held the same or similar position at the same site of employment at the time of the laid off employee's most recent separation from active service with the employer. The second part is problematic, but even the first part, that if you would leave, again, we wish we could bring back people, but right now you have to bring back people who can do any job. And right now you have managers who have obviously seniority, doing jobs that are pay scales maybe 1, 2, 3, 4 steps below, just to try to keep the doors open. So we ask that you just consider the true practical effect here. I also represent Hopkins, to the extent that this affects them. It's the similar and same arguments. Idea is to get the doors open and hire as many people as possible. I'll stand for questions.
Thank you, Frank. And if there's no questions from my colleagues, we're going to move right ahead. And of course, if there's anyone out there who wants to speak, please use the raise hand function so we can see you, so we can call on you.
I believe Amy Rohr, president of Maryland Hotel Association, was going to speak.
Yes, she was next on the list. So Amy can go right ahead.
Thank you, Madam Chair, members of the committee. Can you hear me?
Yes.
So this is Amy Rohrer, President and CEO of the Maryland Hotel Lodging Association, and I'm here representing the Baltimore City Council of the Hotel Association. We are opposed to 20-0544, and you have my written testimony. While the bill is well-intentioned, it is targeted at hotels, and we feel we should have had a chance to be at the table with the sponsor to provide input. And at this point in time, we have not had that opportunity. Our industry, as others have indicated, has been completely crippled by COVID-19, and Baltimore City is faring worse than the rest of the state. There are hotels that are still closed in Baltimore City, and some of those that are open and operating are operating at less than 10% occupancy. They are losing money being open, operating at that level of occupancy. They're losing even more money, or I shouldn't say even more money, but they're also losing money when their doors are closed. We may see more closures of hotels in Baltimore City, and unfortunately, some of those closures may be permanent. We certainly never wanted this to happen, and we wish that we could call all of our employees back. And as we do reopen and ramp back up, there is already incentive to hire the best and most experienced employees for the job. However, I want to make the point that forcing hotels to hire based on seniority may not align with immediate employment needs of the business as we are ramping back up. Our industry may be forever changed by COVID-19. Overregulating an already struggling industry could result in permanent business closures, job loss, and related tax loss. This just is not the time to unfairly target one industry with a discriminatory bill without gaining proper input and analysis. We would like to work with the city to ensure the hotels and our employees are treated fairly as the economy regains its strength. And I hope we will have that opportunity. So thank you for your time.
Thank you.
Madam Chair, can I have a second to respond to two things that I think
Yes, Councilman.
may be misrepresentations. The first, I would note that this bill does not require hotels to hire people. unless they reopen. So if the hotels are not in financial position to do so, this bill does not require them to do that. And that is a mischaracterization of what's being proposed. I would also note that I'm very much open to conversation with anyone, but there were no efforts to reach out to my office from the Hotel and Lodges Association. And so the characterization that they were not brought to the table is not a fair one if they were not, have never reached out to request a meeting or anything of the like. I did speak to Mr. Boston, their representative, a few times about this bill, but Mr. Boston also did not request a meeting with the Lodges Association. So I just wanted to clarify those two key pieces for the record.
Thank you. And if it's no other comments from my colleagues, we're going to jump right in to the callers who are on the line. And so we have about 12 callers that are on the line. And so we can move with caller 1. You'll hear 3 beeps, and then you can start speaking. Caller 1. Caller 1, do you want to testify? All right, nothing from caller 1. We're going to move on to caller 2. Caller 2, would you like to testify? Nothing from caller 2. We're going to move on to caller 3. Caller 3, would you like to testify?
Not planning to.
Not planning to. Okay, thank you. Caller 4. Anything from caller 4? Caller 4, we hear you. Do you want to testify? Nope. Okay, we're moving on. Caller 5. Caller 5, would you like to testify? Nothing from caller 5. We're moving on. Caller 6. Anything from caller 6? We can hear you. Would you like to testify?
Hello?
Yep. Hi, caller 6.
My name is Flora Nadis, and I've been working at the Baltimore Marriott Waterfront for 18 years. And I just want to say we all really want to get back to work, and we want to make sure that we have, you know, the opportunity to and the stability to do, and maybe have some backing to definitely go back to work. Thank you.
Thank you, caller 6. Caller number 7, we're moving on. Caller number 7, would you like to testify? We can hear you, caller 7. Caller 7, nothing? We're going to move on. Caller 8, will caller 8 like to testify? Caller 8, nothing? All right, we're moving on. Caller 9, would caller number 9 like to testify? Nothing from caller number 9. We're moving on. Caller number 10, would you like to testify?
Know how to do the chat.
We can hear you.
And going over highlight and low light. Okay. Okay. All right. Okay.
Caller number 10 seems like he's on another line. Caller 10, we can hear you. All right, we're moving on to caller number 11. Caller number 11.
I don't know if I'm calling number 11. The beep came on?
Yeah,
okay,
we can hear you.
Okay, Elsie Words. I work at Radisson Crown Plaza. It will be 40 years, and I got a laid off sign, and I don't think that it's fair that they don't have to call me back. It's so unfair to me, and I've been on that job too long for this to happen to me.
Thank you, caller number 11. Caller number 12. Would you like to testify? Caller number 12. All right. It looks like we have everyone, so we're just going to move right along. And so what I've decided to do is we can actually, I think it's okay to do vote over the bill, have one vote for the bill overall, and then the the two amendments that are not that complex, I think are number 1 and 2. I wanted to see if the law department could actually look over them, 3 and 4, well, actually all of them, of course, but and maybe get something to us by tomorrow, Monday at the latest, and so we can do floor amendments. Does anybody from the law department want to speak in reference to this? Can we work together with this, get something by tomorrow or get something at the latest by Monday?
Sure, this is Hillary Ruley. We're happy to review the amendments as soon as possible.
Madam Chair?
Yes, Councilwoman Clark.
I think it would be a more simple process, and I defer to you and to the leader of this effort. If we tried to adopt the amendments before us, and asked the law department to look them over tomorrow and Monday morning, they would be on the agenda, but we can always hold them on the agenda or send them back to committee during the council, so that basically with a vote, if the work is not complete or there are questions still remaining, we can send it back. I feel I've spent, like we all have, months and months with people who are trying to even get through to people about their jobs, about unemployment, this is what this bill is it's a way in the door to where you're from without needing to call 1,000 people that don't answer the phone or come up against a locked door. I think it's urgent. And so I would like to see the bill voted on with its amendments. And Madam Chair and Councilman Burnett, we could always, if it's not cooked, pull it off and put it back in the oven by a motion on the floor of the council on Monday. That way we know what we're looking at, so does the law department, and they won't be worried that it's going to change because there it is already on the agenda.
Okay, so let's move on. Thank you, Councilwoman, for your suggestion. So let's I'm going to put out, do we have a motion for the
Madam
first
Chair?
amendment? Did
Madam
somebody just
Chair?
say something? Yes.
This is Council President's office. If you could just hold on a motion for now. In fact, if you could just recess for a brief moment, and I'm gonna give you a phone call.
Okay, hold on everyone for one moment. Okay, we are back. So there's been some, MPC is back. Okay, so there's been some major concerns with this bill that we are just going to hold off on because this is an important bill. I don't think it needs to be rushed out. I think all sides need to be heard so we can get it right, so we can help the people of Baltimore City. And so therefore we are going to stay in recess. We'll come back to this on Monday at 10 a.m. And that way the law department has the proper time to look over the amendments and we can get everything in and just really represent the people of Baltimore City. So I understand your concern, MPC, but I'd rather not rush so we can do this right. So for this, if my colleagues don't have anything else to add, we'll go into recess and we'll come back at 10 a.m. on Monday with the law department having everything on hand, okay? All right, thank you everyone. Have a good weekend.